Hi all. So welcome to the business law, business contractual relationship lesson. The consideration today is to discuss about the conditions and warranties and transfer of property, performance of contracts of sale. But today's lesson, though this is the topic that we are going to discuss, but of course I'm expecting to discuss about the conditions, warranties as well as the caveat emptor rule. Right, we'll first go to the lesson outcomes. The first one is the explain and understand the terms of conditions and warranties and distinguish the terms. Understand the nature of implied and express conditions, warranties, and see the applicability of them with circumstances pertaining to the sale of goods or the agreements to sell the goods. Evaluate the caveat emptor rule or the doctrine of caveat emptor. Right. So the transfer of the properties and the performance of the business contracts will be discussed in our future sessions. Fine. So we'll move to the lesson. What do you mean by a contract? Now, as you all know, in agreements, in business contracts, we include some of the terms and conditions. And there you can see some of the conditions are included. Let's say, before we define this concept or the terminology, some of requirements are included in the means of conditions, and some of the things are included as the warranties. Let's see what are the differences between these two, right? The first one is a condition. Now, condition is a stipulation essential to main purpose of the contract. It's a stipulation to the main purpose of the contract, and the breach of such gives the aggrieved party a right to repudiate and also to renunciate the contract itself. What do you mean by this? Now, as an example, you and me are having a contract, right? We both are having a contract, and let's suppose in a circumstance, this is pertaining to the main purpose of the contract, right? Let's say supply of water. I'm the water supplier, you are the company. So myself and you are having an agreement between we both. So in that case, I will agree to provide or to supply the water at a cost of X amount. So you have an agreement with me to pay me X amount for the amount, let's say, for the number of bowsers that I supply to the company, right? So in case of, let's say, this is a contract, right? That is the main purpose, right? Supply the water. Now in that case, if just because of it can be accidentally happen, let's say I may be unable to provide you, or let's say supply you the required numbers of bowsers per day, let's say on a date. In that case, it's a condition which is included in the contract, so you can repudiate the contract. What do you mean by repudiation? It's like you are going to reject or you are not going to accept it, right? So which means that it's like, it may consider as a breach of contract, where I supposed to supply the water, I couldn't. Because of that, you consider it as a repudiation. So you can cancel the contract and you can go for another supply. So this is one way of conditions, right? It's a condition. Now, what do you mean by a warranty? Warranty is similar to that, right? But there's a difference. Let's think about the definition of the warranty. Warranty is a stipulation collateral to the main purpose of the contract, which is collateral, right? The breach of such gives the aggrieved party a right to sue for the damages, right? So better we include the conditions other than we include warranties, right? The difference between these two is condition cannot be sued at the courts, or let's say it cannot be sued. Like anyway, you can challenge over the conditions, whatever you have included in your agreement. But of course, warranties, of course, in terms of legality, warranties are a bit sort of scary, because there's a huge ability to the affected party to sue over the breach of warranty. It's not like breach of condition. Like, of course, the breach of condition can be considered as a breach of warranty. in some circumstances. But when it comes to the severity of these two, breaching a warranty, breach of a warranty is much severe than breach of a condition in a contract, right? So the party is reserving the ability to sue over the other party on the grounds of warranties. Right, we'll move further. Distinguish these two terms as the condition and the warranty. We can distinguish them based on three factors or three bases: as to value, as to breach, and as the treatment. So why are we differentiating these two? When it comes to the value, as to value to the contract, condition is a stipulation to the main activity of the contract, right? But when it comes to warranty, it's a stipulation which is collateral to the main purpose. See the difference between these two. And as to the breach, let's say if you breach a condition in a circumstance, the other party has a right, let's say he or she is having a possibility to reject, or we'll call it as repudiation, repudiate or to renunciate that particular contract without performing it. Simply, if you were unable to provide the accepted, or let's say agreed amount of the numbers of bowsers of water, so the company can let's say the company can repudiate it, reject it. But if you breach a warranty, it's much severe because the other party can sue over the damages and claim over the damages. Third one is as to treatment. Now, when it comes to a termination, or let's say when it comes to a breach of a condition, it can consider as a breach of warranty, right? It's very severe. But when it comes to a warranty, it cannot be considered as a breach of condition, right? So these are the three things where we are considering about differentiating between these two conditions and warranties. Okay. Then, two principles to be considered in treating the breach of condition as a warranty. Now, to consider a breach of a condition as a breach of a warranty, you must have these two types of principles in it. The first one is voluntarily waiver by the buyer. Now see the circumstance according to the presentation. Breached by the seller, the buyer reserves the right to treat the contract as repudiated and reject the goods, or consider the breach of condition as a breach of warranty and claim the damages from the seller. Now this is a sale of goods, right? Breached by the seller, the buyer reserves the right to treat contract as repudiated. Now let's suppose if you have agreed with the seller to send whatever the commodities that you already purchased to your premises, right? It's a sort of a contract, right? You haven't paid yet. So under that circumstance, the seller is liable to send the commodities to you. Though the title of the good is held by you, but still this seller has to perform it. If he is refraining from performing it, you can consider that the seller has rejected his whatever the the duties and the responsibilities. Because of that, you can consider the agreement is repudiated by the seller, and you can sue over the damages by considering it as a breach of a warranty. That is one way. Second one is acceptance of goods by the buyer. Now, in the condition of acceptance of the goods by the buyer, if the buyer has accepted the goods and comes to know the breach of the condition, the buyer can maintain actions for damages but cannot reject the commodity. Now, since you have already almost accepted the commodities which are sent by the seller, right? So you cannot reject the commodity, but of course, if you know that there's something called breach of condition or breach of whatever the terms included in, so you can still have the you have the right to sue over the damages which are caused in that case. Okay, we'll move further. Then, as you can see, The next one is expressed and implied conditions and warranties. Here today I'm not expecting to cover about the implied warranties, but of course I'm going to discuss about the implied conditions. See, these are very severe. So whenever you are coming to the agreements, you must be careful with these expressed and implied terms and conditions. Why is that? Expressed, of course, we can clearly see in your letter of contract, or let's say the contract of appointment or whatever. Easily you can see because all these matters are expressed, written, right? Clearly you can see. But what are the implied terms and what are the implied conditions which are not included, but those are enforced by the law, right? Something is expressed, something is implied. The two sides of a same coin. Be careful with that. Go to that. Express conditions and warranties are mentioned as a condition or a warranty in the sale of contracts of goods. But implied conditions are like conditions as to title. Now, as an example, if a seller sells, the first one is condition as to the title. If a seller sells a product to you because he is having the title of it, right? In the case of selling, he transfers the title to you. He is selling that particular product. He sells that particular product because of what? Because he is having the title. Let's suppose that the seller who sells the product to you doesn't have the title over it. Without knowing, without having this type of information, because without knowing the title of the actual title of the good, you will buy it. Then the person who actually owned it, right, is still having the title over the goods. Why? Because we don't know. Let's say A is there, A, B, C, three parties. Now B is trying to sell a commodity which belongs to A without getting his prior permission to C. Now C is buying it without knowing about the information which title still belongs to the person called A. So this is sort of a mistrust. I mean, it's sort of a misrepresentation which has done by the B, right? Now B sold the commodity, let's say, in a circumstance where the legal rules, to see the severity of this. Now let's suppose A is having sufficient documents to prove that the B is not having the ownership or the title over it. If so, now the C's responsibility is to return or transfer the commodities, whatever at his possession, to A directly without considering about the B, right? All these damages which happen to C has to be bared by B under that circumstance, because he didn't have the sort of a title to sell it. To become the seller, you must be having the title of the goods, right? Or even if A asks you to do so, you can be an agent. Under the agency, you can sell them to the C. Hope that is clear. Condition in a sale by description. Now, most of the companies are ordering some of the commodities by the description. They will be giving you the specifications, whatever the need, whatever the things that you need to include in a particular product. And if the particular product is having that sort of specifications, they will buy. Now, in a sale by the description, it says by the law it is enforceable to provide with a consumable good with that sort of, that should comply, the product or the commodity which is sent to the buyer should comply the necessities or the prescribed qualities of the particular description. Let's say, as an example, in nowadays, the present case, in COVID-19 case, we are sending some of the list of products or list of commodities in a way of WhatsApp or Viber, whatever, to the seller. Now the seller has the right to check the list, right? Now we have already given an offer, no? So because of that, he can check this description, and accordingly he can make a sort of a commodity pack. Let's say it's a good pack. Now, once you receive the good pack, let's suppose that not the amounts, right? The goods that you described in your description were not there, right? It's a matter of condition in sale by description. Now, if you are trying to get some amount into the description, the commodities which are included in that particular description has to be there in real. That is the condition under the condition in sale by description. Then the next one is condition in a sale by a sample. Let's suppose if a company wants, or if a consumer wants to look at a sample, right? In a circumstance, you may provide it, right, as the seller. Now, once you provided the commodity, or let's say it's as a sample, a single individual unit, to let's suppose that the person who wants to buy this has placed the order. Once he places the order, the unit that you are sending to him has to be the exact as whatever you have sent as a sample. If it doesn't, let's say you have 3 product categories of the same good, A, B and C, which is C is the inferior. By sending the sample of A, you can't ask him or her to buy sample B. It has to be sample A, right? You have to almost comply the type of sample as it is. Then condition in a sale by sample as well as by description. It's obviously clear, by the description and by the sample you must comply the requirements of the buyer. Otherwise, he has the right to sue over you if it's a warranty. Or a condition, it can be considered as in the sense, primarily it facilitates the buyer to repudiate the contract, right? Condition as fitness or the quality. It's not enough to send the commodities whatever prescribed or whatever requested, but it has to be fitness enough to, and qualified enough to give the same facility, or let's say to comply the need requirement, right? Then conditions as to merchantability. Now, some of the sellers are trying to sell some of unusable products to the buyers, right? But it's an illegal act, because why? The goods should be merchantable. It doesn't mean like it doesn't need to mention in your contract, right? Say a contract of sale of good. If it's a car, it has to be drove by somebody else, right? There should be 4 wheels. It has to be drove, right? So with that, merchantability is a type of a condition which is implied by the terms and the conditions. Conditions as to wholesomeness. It's almost same like consumable thing. So these are the things where we are going to consider on the expressed and implied conditions. Then the last page, the last slide, doctrine of caveat emptor. In a circumstance where you may have an agreement with a seller, you may have already bought a product, right? But still, remember, be careful. Whenever you buy a product, you must be careful. You must be having a sufficient knowledge about the product, right? We call this one as the buyer be aware. Buyer beware. In the sense, simply that means buyer beware, whereas it is a duty of the buyer to be careful while purchasing the goods of his or her requirement, and in the absence of any inquiry from the buyer, the seller is not bound to disclose any sort of information or the defects affected or in the goods of which he may be cognizant. Of which he may be cognizant. In the sense, even though the person knows, let's say the seller knows, right? Mostly these things are happening in the vehicle yards, let's say the car sales. Even though the defect of that particular car is known to the person who sells it, they can still hide them. If you have not inquired about that particular damage, they won't tell you, because it's up to the buyer to be aware about the products, to get the information from the seller by asking. If somebody says, let's say, in a case where you are challenging over that sort of a condition in the courts of law, the law will accept the seller's statement saying that the buyer didn't inquire about the product defects from my end, even though I was known to them, but still I didn't reveal because he didn't ask. So that is the exemption case, right? So we'll move. There are some exemptions, but still, though there's a responsibility of that is the responsibility of the buyer to get to know about the product features and whatever the defects available in the product, but there are so many exemptions given by the court of law to secure the buyer, right? So we'll see the exemptions. So what are the exemptions? Whereas the seller makes a misrepresentation and buyers relies on it. Sellers cannot tell us lies and misrepresentate. Misrepresentation in the sense, it's a like fraudulent activity. Misrepresentates. In some cases, they may tell lies. In that case, of course, you can sue over the courts for the damages, right? Suppose that the second one is, whereas seller makes false representation amounting to fraud and buyer relies on it. Amounting to a fraud, somebody will tell you lies or misrepresent it. This is the world's most fuel efficient car. Then that is cause of, to get the fraudulent conduct in the sense to earn a profit. He will try to sell that particular car to you, right? So in that case, you can sue over the courts. Goods are purchased by the description and they do not correspond with the description, can be sued over the courts. And also, whereas purchased by the OA, even by considering all these things, you can repudiate. At the very first stage, you can repudiate, or even considering this breach of condition as a warranty, you can go for the courts to sue over the damages. Then, whereas purchased by the description, yet goods are not in a merchantable quantity. As I told you, they are not usable or they are not qualified enough to sell to another, right? It's not a merchantable quantity. And goods which are bought by sample, which are not complying the quality of the sample, can also be not counted under the caveat emptor rule. So the things will be exempted. Right. So thank you very much for attending for today's lecture. Hope to discuss about the implied warranties and transfer of the properties of goods by our next week presentation. Thank you very much.